Hello and welcome to episode 15 of Estate Planning Weekly. Today I'm answering a common question that I receive regarding whether or not your personal representative or successor trustee can just rob your estate blind and do whatever they want. Clients are often concerned with the powers that they're granting to a third party. As always, I'm your host, Don Rolfe. I'm the owner and founder of Northwest Legal Planning, an estate planning and probate law firm located in West Lynn, Oregon. Now, to those personal representatives and successor trustees. Essentially, the short answer to the question as to whether or not they could abscond with everything in your estate is yes, they could. Most likely they'd be caught and held accountable for it. It is a crime, it's theft. They're in a fiduciary position, playing a role in making sure that your creditors are paid and that your beneficiaries and heirs are receiving the assets that you've directed. In reality, that just doesn't happen. You know, you're going to appoint someone to those positions who you know and trust, and very likely they are not going to be stealing anything from your estate. Furthermore, when it comes to probate in Oregon, depending upon if you have a will or you don't have a will and the powers that you've granted, there could be requirements for a bond to be posted by the personal representative. The court has oversight over what gets paid out of accounts. They keep tabs to make sure that creditors are being properly paid and that beneficiaries are receiving the inheritance that you've set out in your will. And on the trust side, generally beneficiaries are pretty knowledgeable about what's going on. As soon as you are gone, your beneficiaries will probably be receiving notices and be requesting copies of the trust document so they can know what's going on and be able to keep tabs on the trustee. If all else fails, and there is a problem, your beneficiaries always have the option of filing something with the court to say, you know, something fishy's going on here, we need to take a look at this, can we get this rectified? But in a vast majority of cases, 99.99999% of cases, there's not going to be any issues with a personal representative or successor trustee overstepping their bounds. Now, what are they allowed to do? Well, in both a successor trustee and a personal representative's powers are derived from two places. So the trust and the will that you create will give specific delineated powers to those fiduciaries, and then also the state statutes for both probate and for trusts will set forth powers that those people will have in those roles. And generally what it is that they're going to do is gather up all of your assets, your cash, your cars, your furniture, your clothing, your real property, put those into either an estate account with a probate or into an administration account for your trust, tally that all up, gather up all of your bills, any final expenses, any credit card debt, anything that you have that you have to pay out, any obligations, and they'll pay off the creditors, and then what's left, they'll look to the documents that you've created, or if you unfortunately pass away without having created an estate plan, they'll look at the statutes to see the order of who is to get assets from your estate. If you've spelled it out, hopefully in a trust or a will, your personal representative or successor trustee will look to those documents to see who is to get what, whether or not, you know, Billy's to get your Mustang and Sally's to get the Corvette, whatever it happens to be, and make sure that those assets are paid out to those beneficiaries or your heirs as you've set forth. So again, the short answer is yes, there could possibly be some issues, but in reality, it just doesn't happen that often, especially if you've taken the time to appoint people that you know and trust to those positions. It's something that almost all of my clients have at least a little bit of struggle trying to find those people, but when you do find them and you get the right people appointed, it makes all the difference. If you have any questions about estate planning, hopefully you're not in the group of people who don't have any estate plan and are leaving it totally to the statutes as to where your assets are going to go, who gets paid first. Hopefully you do have an estate plan. If you don't, feel free to reach out to me. You can click on the link below over to my website and schedule a free complimentary 30-minute consultation, either by phone or in person. I would be happy to meet with you and answer any questions that you have. I appreciate you being here and watching. Thank you, and I'll talk to you soon.